Shall we start? Well, welcome to World Arbitration Update. This is a World Arbitration Update from Singapore. This is the third year that we do it in Singapore. This is very much thanks to K&L Gates, and especially thanks to Robert Houston and also Raja Bose, who is going to be our moderator on a panel that will discuss mainly the strategic lawyering involving contract or treaty breaches and human rights violations. And I apologize because I did not introduce myself. My name is Jose Antonio Rivas. I am a partner at Extragy LLP here in Washington, D.C., which is a boutique law firm on investor-state arbitration and also public international law, as well as international commercial arbitration. I'm also a professor at Georgetown Law, teaching investment arbitration. And together with Ian Laird, 4 years ago, we co-founded World Arbitration Update, which is a forum that provides or has two main objectives. One is to update on issues of investment treaty arbitration, international commercial arbitration, as well as public international law. And two, we at World Arbitration Update, we're trying to decentralize international arbitration, noting that as incredible venues as they may be, Paris and London and even Washington, D.C., as well as New York, they are not the only centers of arbitration in the world. So we really want to reach out to every other center, because we know that there are fantastic council arbitrators in Asia, in Latin America, in Africa, in Western Europe, etc. So with that, I will now pass to introduce our moderator. Raja Bose is leads the K&L Gates Straits practice in Singapore and Asia. He is has 20 years of experience in international dispute resolution and has worked in both London and Singapore. He is qualified both an advocate and solicitor of the Supreme Court of Singapore, as well as admitted as a solicitor of England and Wales. He is also a qualified arbitrator and is a fellow of both the Chartered Institute of Arbitrators of the UK, as well as the Singapore Institute of Arbitrators. Raja is on the panel of arbitrators of a number of arbitration institutions, including SIAC, KLRCA, ICA, and HKIAC. He's also a board member and director of the UK Chartered Institute of Arbitrators in Singapore branch. Raja has experience conducting international arbitrations with seats in Singapore, Hong Kong, Indonesia, Vietnam, China, India, Dubai, and many other countries. With that, I would leave you to, I will yield the floor to Raja, and welcome everyone to World Arbitration Update.
Thank you very much, Jose. The only correction I would offer to the bio is that unfortunately I now have 30 years of experience, and I was not particularly thrilled to learn that 3 decades have passed studying and learning rather about international arbitration. But welcome everybody. My name is Rodger Bose. As Jose said, I'm based in Singapore together with my colleague, Robert Houston. We are active members of our firm's investor state practice, and we're very thrilled to host this event. As Jose said, this is our 3rd year that we are doing this. And we hope to present to you a very interesting topic that has numerous dimensions that we have had to contend with during the course of our practice the last 12 to 18 months. Next slide, please. The context to many of our comments come from our work done across the globe, 5 continents with 48 offices. The interactions we have with our colleagues from all these offices provide useful and necessary insights into the practice of international law. Today, we're going to focus on strategic lawyering involving contract or treaty breaches and human rights violations. I'm going to spend a few minutes to put the discussion that will follow in some context so you can understand where we are coming from. It is a well-known paradox that notwithstanding, whilst globalization has resulted in increasing uniformity in the lives of societies across the world, it has paradoxically also led to increasing fragmentation as more specialist legal regimes and rules, conventions, principles of international law and domestic legislation emerge to deal with specific issues that impact society, trade, culture, and life in general. This fragmentation has been accompanied by the development of almost in parallel but separately autonomous rules, legal institutions, international conventions, domestic legislation, and principles of practice among states. What used to be referred to as international law today breaks down to, I last checked, at least 11 specialist areas of international law, such as international human rights law, investment law, trade law, the international law concerning armed conflict, business and human rights, the law of the sea, migration and refugee law, environmental law and climate change, international criminal law, public international law, and private international law. The emergence of these new and specialist areas of law containing self-contained remedies, often in geographically or functionally limited treaties, creates problems of coherence in international law. Yet, aside from the potential for large-scale conflicts between human rights law on the one hand and investment law on the other, for example, these give rise to challenges at a more macro level, more micro level. Issues such as global concern for climate change, fisheries depletion, and human rights do not fall neatly into any particular bucket. And there's a constant need to mediate and understand the interaction between these regimes. This also comes up in our day-to-day practice where we find traditional causes of action, a breach of contract, a breach of a treaty, are not available because they have been lost, because there is an obstacle, because there is no treaty, because the cause of action is time-barred. And that has forced us to look beyond the straight and narrow as well, and to think out of the box when it comes to what can we do to bring justice for the client through avenues that would not normally occur to black and white lawyers that we were trained to be. Whilst regime interaction between these different things is a very broad area, we are, to make what we are doing today more bite-sized and manageable, we are going to focus on a subset of regime interaction, and that is the focus of international human rights and contractual obligations. At the risk of overstatement, how do international human rights impact and possibly conflict, or at least come into tension with contractual rights and investor state rights? Take, for example, the underlying investment contract usually relates to the exploitation of a natural resource or the development of greenfield public infrastructure. The it necessarily will impact the rights and lives of indigenous people living in the affected areas. It is not uncommon that in the execution of the project, environmental concerns emerge, pollution and effluent from factories and other infrastructure that's built. The treatment of local labor forces, the outbreak of disease because of unsanitary conditions. The project becomes unpopular. It is used as political football between rival political parties, and creates civil unrest leading to military action, and ultimately the relationship breaks down. The state then is accused of heavy-handed action in criminal prosecution of the individual concerned, incarceration of the principals, and with cross allegations of each side having breached obligations to people in weaker positions than them. So to understand what issues emerge and how you navigate them, I'm honored to have three very distinguished speakers with us today. Stephanie is an assistant professor of law at SMU and the Yong Pao School of Law. She will be speaking to us about the framework of international human rights and in the context of international disputes. Maria Lucia Casas, I hope I pronounced your name correctly, will be speaking to us on contract breaches involving human rights violations. Rodolfo, is a counsel at Clifford Chance in Perth. He will be speaking to us about treaty breaches involving international human rights law. And finally, my colleague Robert, who's a senior associate here based in Singapore, will approach the tricky topic of a holistic development of a legal strategy in human rights cases. I have a slightly more detailed bios for each of my speakers, which will circulate in the handouts at the end of today's session. And with that, thank you very much, and I'd like to hand over now to Stephanie.
All right. Anything I need to do?
Okay.
No, leave it. Just leave it. Maybe the volume from Stephanie's computer.
Okay, can you hear me? Okay, great. And thank you very much, Rodger, for the introduction. Many thanks to you both, Rodger and Robert, for inviting me. As an academic, I am looking forward to learn from practitioners. It is always good to have these kind of conversations. So I was invited to speak and really set the frame, I guess, for this discussion that we have today, and remind everybody of the general overview and framework of international human rights as they developed right after the Second World War. So what I will do, let me see if I can switch. So what I will do, really go back to the foundations, quickly speak about the typology of states' obligations, briefly restrictions and derogations, and then also the mechanisms of protection, which are in a human rights context, judicial and non-judicial mechanisms, as well as the particular issue of the exhaustion of local remedies. So when you go back to the foundations of when it all started, human rights as part of public international law really started after the Second World War. There were some bits and pieces, if you think of the International Labour Organization, already before the Second World War, but it already started with the Universal Declaration of Human Rights, proclaimed in 1948. It is the historical milestone document that set the basis for a number of treaties. As of today, over 70 human rights treaties have been concluded. Most important among these treaty-based instruments in the human rights, international human rights, are the two covenants, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights, both adopted in 1966. The other types of conventions that are part of the 9 most important human rights treaties, as there are these universal human rights treaties, are the convention dealing with specific wrongs. So very famous, of course, is the Convention on Genocide and the prohibition of torture. We have also conventions related to the protection of specific categories of people. Here, these would relate to refugees, children, women's rights, and so on. You see here in gray the universal system that is generally divided into those that are treaty-based. So the list here in the middle, and then also the charter-based. The charter, the UN Charter, refers to human rights and in Article 76, as well as in the preamble, and it is of course a cornerstone of the UN system to promote human rights around the world. In the charter-based system, we have the UN Human Rights Council, and under the treaty-based, we have a number of treaty bodies that relate to each of these treaties. Now, I have on the slide the two that relate to the 2 most important covenants, the Human Rights Committee and the Committee on Economic, Social and Cultural Rights. Now, the human rights system is very much related also to regional systems, and the European Convention on Human Rights, adopted in 1950, was the first one that set the implementation and further judicialization of a supranational system on human rights in the region of Europe. It was then followed by the American Convention on Human Rights, and later African Charter on Human Rights and People's Rights. So the Africans have this addition on the people's rights, which are more community rights, and the latest one, the Arab Charter on Human Rights of 2004. Now the European, the American and the African, they have regional courts, as well as commissions, which are the non-judicial bodies. I will come to that towards the end of my presentation again. When we now move on to the types of states' obligation, I did not want to make the slide too full with a long list of the substantive rights that are in the list of international human rights. I'm just reminding you of a few: the right to self-determination, equality, non-discrimination, right to life, freedom from torture, freedom from slavery, freedom of assembly and association, freedom of expression, due process, right to work, right to education, cultural rights, rights to health, and also the international human rights as they evolve, change, and new rights are added. Some of you might have heard of the recently added right to a healthy environment, confirmed by the General Assembly in July 2022. So rather recent. States' obligations under international human rights law: respect, protect, fulfill. Certainly 3 buzzwords that many of you have heard. It dates actually back from a report that was written by Mr. Eide, the Norwegian diplomat, if I'm not wrong, who started really this typology. And it is very useful because it gives an operational content to this type of rights and the state-centric responsibility that we find in the system. Respect, as an obligation for the state, means to abstain from interfering with the existing enjoyment of human rights. Protect means the obligation to protect individuals and groups against human rights abuses. So states must intervene in private relationships. This is a duty to actively interfering, but it is an obligation of means. Then fulfill, this is the duty for states to take measures that ease the fulfillment of the realization of human rights. So this might require states to provide certain goods or services for individuals that are unable to cure them by themselves. For example, healthcare, right, as a right, or a job, or to sustain their living. Now, I have on the slide the question of the international human rights in the private domain, just as a potential segue, of course, to what we're going to discuss in this seminar, is this question about is there a horizontal effect, meaning that also private actor, and of course the first entity that we might think of are powerful multinational corporations, should they also bear the responsibility to of human rights as states do. Now, some might say, no, this is still the state's monopoly of human rights, and where others see that given their power and influence, there should be a horizontal effect. Now, we know from the Ruggie report on corporate responsibility to respect human rights is that from these three, respect, protect, and fulfill, the respect to human rights has been, in a way, enlarged to corporate responsibility as well. And here it means that the corporation should act with due diligence to avoid infringing on the rights of others. So meaning that at least due diligence is made that human rights are being respected. And where there is a risk of potential human rights violation, that these risks are mitigated. And you see this in many of the recently adopted due diligence legislations that come from certain jurisdictions. However, that said, the system as it stands until today is state-centric and puts the burden of responsibility on states. Very briefly on restrictions and derogations of human rights, which also introduces somewhat a hierarchy between the different rights. So as in any constitutional system, the freedoms can be restricted, and the conditions here too are by large in the proportionality assessment. You would need a legitimate objective. It needs to be transparent, non-discriminatory, and non-arbitrary, and the measure needs to be proportional, so proportionality, stricto sensu, that the measure taken is actually necessary in order to achieve the legitimate objective. This is for restrictions. Now, derogations in treaties are allowed in real cases of absolute emergency. This is public emergency under the ICCPR, and in times of national emergency under the European Convention for Human Rights. Interestingly, the African Convention on Human and People's Rights does not contain a similar derogation provision. Now we find in the ICCPR, take this here as an example, also that there are certain rights that can never be derogated, and this is, so they have an absolute character. The list includes the right to life, the prohibition of torture, prohibition of slavery, prohibition of punishment without law, and prohibition of arbitrary detention. Right. I come back now to the mechanisms of protection, and here the landscape is, of course, depending on what kind of instrument we are talking about. Again, if we talk about the Charter and the UN Human Rights Council, this is not a judicial body at all. It is a political body. We have from the UN system resolutions that can be adopted on issues of human rights, and also what I mentioned earlier, for example, on a new recognition of a human right, such as the right to a healthy environment. In the treaty-based system, we have these committees, which are non-judicial bodies. However, there is a possibility for individual complaints under the ICCPR, but only if the optional protocol has been ratified. In interesting when it comes to the mechanism of protection, and that is why the regional systems are in that respect so powerful, is that they come with an actual judicial proceeding, allowing for individual complaints. So very well known is the European Court for Human Rights, the Inter-American Commission, and a court. So commission would be the non-judicial body, the court would be the judicial body. African court that is fairly recent from 2004. In the Arab context, we only have a committee so far. So again, non-judicial. Now, what is specific, or not specific, but what is certainly something to that is different from investor-state dispute settlement is that in the human rights system, before an individual can go to any of these courts, there is the exhaustion of local remedies. And the rationale behind the exhaustion of local remedies was that these courts were not seen as a appellate mechanism, but rather as a subsidiary function or a complementary function to national courts. So the human rights system, I guess this is also an important point, very much relies on national judicial systems and national courts. So for the ICCPR, if the protocol is ratified, there is also an exhaustion of local remedies. Now, the conditions and also the exceptions of when the exhaustion of local remedies applies or is actually excluded has very much been developed in the case law of these different judicial bodies. I think with this, I don't want to enter into more of these details, but I think that probably sets the scene for our discussion today. Okay, thank you very much.
Thank you very much, Stephanie. It was remiss of me to have not properly introduced you. I was going to do that before each speaker made their presentation, so albeit after the fact. In addition to Stephanie being an assistant professor of law at SMU, for the last 3 to 4 years, she has concurrently held a number of appointments, being a member of the Academic Forum on Investor-State Dispute Settlement with UNCITRAL. She's also been an advisor to the Asia Pacific Research and Training Network on Foreign Direct Investment, UNSCAP. And for those of you who don't get out much, that is the UN Economic and Social Commission for Asia and the Pacific. And finally, she's also been an associate with IISD, the International Institute for Sustainable Development. She is currently working on an exciting paper on one of her areas of specialization, which are sustainable development in international economic law, business ethics and corporate social responsibility, international trade and investment law, as well as investment arbitration, international energy transition law, and European external relations law. Thank you, Stephanie.
Thank you so
my
much.
apologies for having impressed people about who you are after your talk. But with that, I'd like to introduce everybody to Maria Lucia. She joins us virtually from Bogota in Colombia. She's a specialist in the regulation of renewable energies and energy efficiency. She's a senior associate in X strategy in the arbitration and international law practice. As I said, she's based in Bogota, Colombia. Unfortunately, one of the few countries I haven't had the pleasure of being at. She's also currently an adjunct professor of international arbitration procedure and an assistant professor of public international law at Universidad del Rosario. She also served as a coach for the Philip Jessup International Law Moot Court competition team. Very welcome, Maria. Maria is going to speak to us today about the impact of human rights violations on contractual rights and obligations. Maria, over to you.
Thank you, Raja, for organizing this panel. And of course, you're welcome to come to Colombia and visit. It is a pleasure to be here and to share, of course, this space with Rob, with Stephanie, and with Radolf, and of course with Raja. It's great to see the incredible work that you guys with your firm are doing every year in putting together the chapter of Singapore of World Arbitration Update. So thank you so much for that. So as mentioned by Raja, today I would like to focus my presentation in discussing whether arbitration could be a suitable mechanism to address business and human rights related disputes. And I would like to focus this presentation in two perspectives. From the perspective of investment arbitration without going to substance, because of course, the possible potential breaches might be addressed by Rodolf and by Rob, and from the perspective of contractual disputes. So first, from the perspective of investment treaty arbitration, it is not unknown that there is a tension between the protection of human rights and states' obligations toward foreign investors. Nowadays, the majority of international investment agreements that are in force are typically asymmetrical. This means that what happened is that investment arbitration agreements imposed obligation on host states, but not on the contrary, and not on investors. However, in the past years, we have been able to see a shift in this approach, and this has allowed us to see how human rights issues can actually play a role in investment arbitration disputes and in contractual disputes, as I will address at the end of this presentation. However, something that I want to clarify before getting to the discussion about some of these mechanisms that have been implemented in the past years in investment treaties, I would like to clarify that although human rights concerns can nowadays be reflected in some way in investment treaty arbitrations through a few mechanisms, such clauses that have been included in investment treaties do not give affirmative rights to individuals affected by business-related human rights violations. Rather, at the end, what they aim to protect is the host state regulatory space in human rights matters. And second, the other thing that I would like to clarify is that they do not confer any direct access to remedy for alleged victims of such kind of violations. This is why it's so important in this presentation to also see the perspective from contractual disputes and to put forward examples such as the Bangladesh Accords, which might be a relevant example here to see how human rights issues can actually be solved in a matter through arbitration. So in principle, if we would like to talk about investment arbitration against foreign investors for alleged breach of human rights under international investment agreements, this might presuppose two conditions. The first one is that we need to have human rights obligations on investors on investment treaties. And second, that we need a provision on consent by investors to international arbitrations for such violations. Without these two conditions, this won't work. So this can be possible, of course, by the development of investment treaty practice. And as you know, the fact that investment treaties are part of public international law, and this includes human rights obligations, as has been explained by Stephanie, this has led us to the recognition that foreign investors have duties in the context of foreign investments, and of course that they might have human rights responsibilities. So thanks to this new approach, we can say that currently we can identify 3 regional or international mechanisms that nowadays exist to promote investments using an ESG approach and a human rights approach. So the first of these approaches is those treaties that reflect the need to promote and protect sustainable investments, and that they include human rights and corporate social responsibility references in their preambles and some non-binding obligations. However, the problem here, of course, is that this is not that useful, as preambles generally lack enforceability. So at the end, this is an advance, but this is not the best approach that we need in order to to balance the system and to have arbitration as a mechanism to discuss or to enforce human rights violation. Example of this kind of treaties, we have the Cape Verde Hungary BIT and also the EU Vietnam FTA. That's just two of the examples, but we have several investment treaties with these kind of provisions in their preambles. As a second mechanism, I will mention those kind of treaties that have clauses that aim to preserve and guarantee the right to regulate. In this case, we have the Canada-Colombia FTA, which has a general exception clause in Article 2201(3). And according to that clause, states may adopt measures to protect human, animal, or plant life or health. And I have like a position here, and it's that even if this clause might be clear and might be a very well drafted exception clause, even in those cases, and even if we have such strong clauses as these ones, these clauses might also be rejected by tribunals depending on their interpretation. This is the case of the Ecuador versus Colombia case, in which although Colombia argued that they were not obliged to pay compensation, and they were under this clause exclude liability to pay compensation. At the end, the tribunal in its interpretation of this clause put forward a different position on this. So if we are dealing with this kind of interpretation, at the end, exception clauses in treaties are not that useful because they are allowing state to take certain measures to act in certain manner, but without incurring in international responsibility. So as a third approach, we have those kind of treaties with provisions that try to balance rights and obligations for states and investors. And with this, I mean those kind of treaties that provide as hard law investment treaty obligations to respect human rights on investors. So as an example of this, we have the Nigeria-Morocco 2016 BIT. We also have the Draft Pan-African Investment Code and the ECOWAS and the Protocol on Investment of the African Continental Free Trade Area, which is still not enforced, but at the end is an advance that Africa is doing towards including obligations on investors. So what are the problems that we need to fix here? Because these have been like really good ways to try to solve the problems, and of course are an advance in itself, but they're not like a complete solution. So what we need to fix here is, first, we need, of course, to include obligations on investors on investment treaties, but that's not enough. And this is something that I think that Rob will address later in his presentation, but the other problem, it's a jurisdictional problem, because investment treaties are negotiated and are entered into by states and not by investors. So of course, all investor treaties might lack consent by investors to be bound to these kind of obligations to respect minimum international standards. So what we propose and what we have been actually discussing from our work in strategy with different stakeholders is a particular treaty architecture that incorporates treaty obligations for investors, but not only treaty obligations for investors, but also a possibility to include an annex in which the investors confirm its consent to be bound by obligations regarding human rights. This is what I have in respect to investment arbitration. And now moving to the contractual disputes. The first thing that I would like to mention is, of course, that the jurisdiction in contractual disputes and also in investment treaty disputes comes, of course, from a compromissory clause. And an example of this and how to deal human rights or how to use arbitration to to solve human rights issues is the mechanism that has been established in the Bangladesh Accords. So the Bangladesh Accords is a legal binding agreement that was signed between garment brands. I believe that it was approximately 200 garment brands and trade unions. And the objective of this agreement was to ensure worker health and safety in Bangladesh textile and garment industry. This is by itself, I think that the groundbreaker, because at the end, what we achieve with this Bangladesh Accord is that labor unions agree to arbitrate disputes and agree to arbitrate disputes that are related to human rights. So they agree that arbitration could be actually a mechanism to enforce business and human rights disputes. At the end, what happened in 2016 is that the labor unions that were part of this agreement brought 2 claims against 2 fashion brands. We don't know which fashion brands because this is confidential. And they brought 2 arbitration claims before the PCA. At the end, they ended up settling the dispute. The resolution was not on the merits, but the advance here is that the tribunal decide that it had jurisdiction to resolve these kind of disputes. Of course, there is still a lot to learn from this because we were not able to see a resolution on some discussion on the merits, which is also key here to see how a tribunal might deal with this kind of issues on the merits. But I think that this is a very good example on how arbitration can be used to resolve these kind of disputes. I would like to finalize this by mentioning that the case of the Bangladesh Accords, of course, was super specific, and also it was successful because of the pressure that the industry had back then in Bangladesh. This is not the case of every industry in the world. So we might want to think or ask ourselves whether the model of the Bangladesh Accords can actually be replicated in other industries. But that this is something that we might discuss later in this panel.
Thank you very much, Maria. I'd now like to introduce you to Rodolphe. He's a counsel with Clifford Chance in Perth. He specializes in international commercial arbitration, investor-state dispute settlement, and public international law. His practice covers Europe, the Asia-Pacific, Africa, and North America. And in addition to energy, mining, infrastructure, and telecoms, he has specific focus on space, esports, and cannabis. Rodolphe has acted under most major arbitration rules in various capacities, and he also has experience with WTO disputes and the enforcement of arbitration awards against sovereign states. Welcome, Rodolphe. He will speak to us today about investment treaty obligations and their interface and potential conflict with international human rights. Over to you.
Thank you, Raja, for the kind introduction. And I want to reassure everyone that outer space, cannabis, and esports are just a way to make you believe that I'm a respectable guy, when in fact what I do a lot is energy and mining. So it's very fitting for today's discussion. So it was just a veiled attempt at making you think that you're actually talking to someone that you can respect and listen to peacefully. Certainly, I'm looking forward to the opportunity to discuss with my co-panelists because I've listened attentively to what they have to say. It's extremely interesting, and I believe that the idea of building into treaties some clauses to really target human rights is a very interesting one, and making investor carry the weight of obligations on investment treaties is also a very interesting idea. And so I look forward to discussing it in our Q&A later. I appreciate we're already running a little bit behind time, so I do not propose to read you a list of various violations because believe you me when I say violation of human rights take many shapes, colors, and forms in investment treaty disputes. They happen in various circumstances in respect of various actors, the parties themselves, their witnesses, etc., etc., sometimes even the arbitrators. But what I propose to do now really is to give you a sense of from where the human rights violations can come, and in respect of whom and in what circumstances broadly. So interestingly, we're talking about treaties, right? And as Raja explained at the very beginning, investment treaties, they're part of the big public international law family, just like human rights. So one would possibly believe that somehow they're cousins and they have things to say to each other. They certainly do, but the reality is investment treaty arbitration is pretty much a self-contained domain, really. And if there is one thing already I can say is that no matter the kind of human rights violation we're talking about, traditionally, there is a reluctance on the part of arbitrators in investment arbitrations to mix genres and really factor in the human rights dimension. And to be perfectly clear, this cuts both ways. It is not a way for arbitrators to exempt investors from human rights violations. It's also simply a way to make sure that just the same states are not embroiled, in human rights disputes under the veil of an investment treaty dispute. So the first consideration really is, yes, international investment law, international human rights law are cousins. They're part of the public international law family, but these worlds somehow are not integrated with each other that much. At least, again, arbitrators are not that keen on mixing them up in their dispute. So that's the very first element. The second element is, and I think it's an important consideration, investment treaties, as the name suggests, they are geared toward investments. They are geared toward business activities, first and foremost, right? They are geared toward economic relations, and certainly there are human rights covering the property element of business relations. But then again, this is not the main focus of investment treaties, at least on the surface. Why do I say on the surface? Because what is extremely interesting is that when you read investment treaties, you often come across, as you know, the same clauses. You've got guarantees against expropriations. You've got guarantees of fair and equitable treatment. You've got guarantees of free repatriation of funds. You've got guarantees against discrimination. And just by saying discrimination, fair treatment already, these are notions that are not entirely foreign to the world of human rights law, interestingly. As I said, these are two separate worlds, but not so much, because when you look at the contents of investment treaties, you can see some commonalities with fundamental human rights. As I have already said, when we consider the notion of an expropriation, we're talking about the deprivation of a private individual or a private company's assets, property. There is a fundamental right to enjoying ownership and property, right? Interestingly, however, when you are dealing with expropriation claims in investment treaty arbitrations, that human right aspect of private property doesn't arise so much, and there is a focus really on how expropriation is defined in the applicable investment treaty and more broadly under international law, but without real references to human rights. Okay, so if we're taking first the investor as the object of potential human rights violations, right, as the target of potential human rights violations by the host state, I guess one of them that is never framed that way, though, is expropriation, really, because the state is unlawfully taking away private property of an individual, be it a foreign citizen, right? But really, where the core of human rights violations, I suppose, can really be observed is under the big umbrella of fair and equitable treatment. As you know, in investment treaties, most of them, I dare say, contain some form or obligation of fair and equitable treatment of foreign investors. And I guess the beauty and the nightmare behind the FET standard is that it is not so well defined, and there are many creatures that can hide behind the notion. FET implies obligations on the part of the state that are not just a matter of treating an investment properly. It goes way beyond that. It goes about providing some security, some safety to the investors and to their investments, not committing denial of justice, affording due process. So all of those notions are also contained in the FET standard. And certainly the right to a fair trial, the right to due process is a notion fundamental to human rights. A lot of investment arbitrations revolve around the breach of fair and equitable treatment through a violation of due process, through a denial of justice, and in some cases even through the violations of real personal rights of freedom. Something that is very common, unfortunately, in investment arbitrations are allegations of denial of due process and denial of justice, but not just in civil proceedings or proceedings concerning the investment of the foreign investor, but they also concern the treatment of the people running the investment. Being the target of criminal investigations, the target of criminal proceedings, often in the wake of those investors making a claim against the state, right? So if we're looking at potential human rights violations committed against investors, denial of justice through a misappropriation of judicial proceedings in the host state by the host state is certainly one of them, right? I've spoken already quite a bit about violations of human rights of investors, but one should not think that investors themselves potentially cannot be accused of committing human rights violation. And here, then the object of the human rights violation is no longer the investor, it is the state. Now, the question is, what do we mean really by the state? Do we just mean the organs of the state government? Do we mean the administration? Oftentimes, when state alleges that investors have committed violations of human rights, they don't really talk so much about the investors violating the human rights of the state itself as a government, but more violation of the human rights of its people, right? And that is where I guess the mining and oil element of it comes into the discussion, because in my experience, certainly, and my experience revolves a lot around mining disputes, frankly, the claims that you often hear, the counterclaims or the defenses raised by states against investors in relation to human rights violations, a lot of the time they have to do with the protection of human health and the protection of the environment. What is interesting when you raise the notion of environment and human health is that I think it is arguable that their inclusion in human rights has been growing over time, right? And the notion that an investor would violate regulations pertaining to the environment or would conduct its, say, for instance, mining operations in a way that is adverse to human health, framed as a human rights violation, it is rather a relatively new concept in the field of investment treaty arbitration. Traditionally, what would be alleged is that the investor has violated domestic regulations pertaining to the environment, and that would be raised as a defense to invalidate the validity of the investment, for instance. But what is interesting now is that more and more you see governments defending themselves in investment treaty arbitration, saying not only that the investor has violated domestic regulations, but that the investor has violated the human rights of the local people near the mining site, for instance, right? So in a way, you could say that states elevate the rights of their own people into the sphere of the dispute. Now, whether it is the right forum to do this, again, I think arbitrators, based on what we know from publicly known decisions, are quite hostile to entertain those claims. But there are cases, definitely, where there's been a consideration of the behavior of the investor in respect of, for instance, the right of local population to have access to clean water, the right of the local populations to have access to a clean environment. And certainly there is a trend in the ISDS community of factoring in much more than before the protection of the environment and the right to human health, right? This is why, to tie back to what Maria Lucia was saying earlier, you see more and more in treaties express carve-out and references to language that you would only find before in WTO agreements in relation to the protection of human health, right, and the environment. Finally, the last point I would like to touch upon before passing the baton to Rob, who will go into probably more details as to differences between human rights violation in respect of investors as opposed to states and vice versa, is the notion, and we should not forget, that the arbitral proceedings themselves potentially can be the theater of human rights violations. Because again, going back to the notion of right to due process, right to a fair trial, right to simply justice, there have been precedents of cases where there have been allegations of human rights violations, not by the state, not by the investor, but by the arbitrators themselves in the way they have conducted proceedings, right? So the last angle from which you can observe potential human rights violation investment treaty cases is by looking at the conduct of the proceedings themselves and as to whether those proceedings have been conducted in a fair and even manner. This is not just a theoretical question, but again, given the, I would say, fiercer and fiercer criticism of investment arbitration as a system, and whether it's truly impartial, whether it is geared toward protecting investors, or to the contrary, it is partial to states, more and more the questions of whether arbitration as a system to solve investment dispute really is fair and to the core, whether it respects the rights to a fair trial and to an impartial adjudicator. So thank you. I think that's enough for now in terms of overview, and we will delve into the thick of it during the questions. Thanks.
Thank you, Rodolphe. You're quite right. It is fascinating. I've got a host of questions for you, but I'll bite my tongue till we let Mr. Houston go. Robert Houston is an associate working in the International Arbitration team of K&L Gates. He focuses almost exclusively on investor state and public international law matters. He has experience conducting arbitrations under ICC, ICSID, SEC, SIEC, and UNCITRAL. He also happens to be the pro bono coordinator for the Singapore office and is leader in the firm-wide anti-human trafficking initiative, in which he has coordinated a number of multi-jurisdictional pro bono projects involving 30, 40, sometimes upwards of 50 different countries in the projects he works on. He's a master at organization, that's what I will say. Prior to joining the firm, and this is certainly more interesting than what he does today, he represented the US and Singapore through the development of a scholarship related to the use of international arbitral process to resolve disputes. And even more importantly than that, apart from being a Fulbright scholar, he served as a captain in the 171st Infantry Battalion of the Maryland Army National Guard and earned the US Army's Meritorious Service Medal for his work at the US Battalion Communications Officer deployment in Egyptian Sinai with the Multinational Force and Observers Peacekeeping Mission between 2011 and 2012. Robert, over to you.
Thank you, Rodger. Hopefully everyone can see my slides here. We're going to shift gears a little bit and not look at substantive law as much as we have been so far, as interesting as that is, and talk about something different, mostly the development of a legal strategy, how to approach matters that involve human rights in the international context. We'll talk in particular about holistic lawyering. Holistic lawyering in international disputes. We'll begin with talking about what is this thing, holistic lawyering, and then over to what does it mean in the international context. Then we'll move on to talk just a little bit about what Rodger discussed in the beginning about regime interaction and holistic lawyering. And finally, we'll talk about how it looks in practice a little bit. So first off, what is holistic lawyering? According to traditional standards of public defense, I did a good job. Indeed, Lisa received a high-quality legal defense in her criminal case. I raised all appropriate challenges to the police conduct, challenged the prosecution to prove its case beyond a reasonable doubt, and litigated her case effectively, zealously, and without compromise. I appealed her case and eventually won her freedom. So why does Lisa still haunt me almost 2 decades later? Because while I addressed the needs of her criminal case effectively, I did nothing to change her life, to address, in other words, her human needs. Those needs, left unaddressed, would eventually drive her back into the criminal justice system and into that same prison cell from which she narrowly escaped the first time. Looking back, what Lisa needed was an advocate who could look beyond her criminal case to her drug addiction, to her homelessness, and to her psychological needs, which stemmed from years of trauma and abuse. Lisa needed an advocate who regarded her as a whole client rather than as a case. So this came from an article written by Robin Steinberg, How Holistic Representation Makes for Good Policy, Better Lawyers, and More Satisfied Clients. It's over in the New York University Review of Law and Social Change, back in 2006. Robin had spent 20 years and more with the Bronx Defenders, a nonprofit that effectively represents folks who are living over in the Bronx in a context just like what she described. And it's interesting, if you look at the article, that you see a dichotomy that she presents, 2 different views, 2 different kinds of approaches to lawyering. One is what she puts forward and is arguing for, effectively holistic lawyering. And the other one is more what we'll be used to when we think of lawyers and traditional lawyering. Traditional lawyering, from the article, it's characterized as follows. It challenges police conduct. We're talking, of course, here about the criminal context. We're talking about public defense. It challenges prosecution to prove the case beyond a reasonable doubt. It litigates zealously, effectively, uncompromisingly. That's what we think of when we think of traditional lawyering for a client in that particular context. Holistic lawyering, on the other side, is portrayed a little differently. Not just, of course, obviously, the aspects of traditional lawyering are included there as well. Representation in court is the same thing. But still yet, holistic lawyering in the style that Robin has put forward includes also a consideration of social services, health treatments, maybe counseling, maybe employment counseling, the things that are behind the issues that have driven clients to be where they are in that context. Also, it's characterized by collaborative, long-term, intensive, and maybe most importantly, compassionate lawyering. The difference is mindset. A person's way of thinking and their opinions is one definition. Changing a person's way of thinking and their opinions when that person is a lawyer has a great deal to do with the result in the case and the way that the client feels, the way the client is engaged with in the process. It's about compassion, a strong feeling of sympathy for people or animals who are suffering and a desire to help them. And it's a funny thing, right? That we're here talking about international law, we're talking about public international law, we're talking about macro issues, right? And yet, where is compassion? Do we have a discussion about compassion? Where does it fit the idea of holistic lawyering in international practice? Well, let's have a look at that. What would it look like if we were to talk about traditional lawyering in the current context where we're thinking of international disputes? We're talking about international commercial arbitration, investor-state arbitration, and maybe some of the public international law disputes that we see out there. We might think of it as a competitive practice. You may have a number of firms that want to get the particular client in the door. A lot of times it has to do with numbers, doesn't it? Amounts in dispute, law firm ranking, number of cases or hearings, number of arbitrator appointments. These are the sorts of things that many folks will look to say, my firm, not that firm. There's a race to arbitration a lot of times. Why is that? Probably has something to do with maximizing billable hours. A lot of times we may think of traditional lawyering in the investor-state dispute in the international disputes world as effectively preparing for the arbitration rather than, for example, trying to find a workable solution if it's possible before the arbitration to reduce costs for the particular client. In the end, it's about quantity over quality in a lot of ways. What would holistic lawyering look like? Not in the public defense context or the public defender context, but here in the context of international disputes. Well, for one thing, it would be client focused, that's for sure. It would start with the client's needs and concerns. It would involve a great deal of counseling and advice, more so than simple representation before a tribunal. It might involve some practicality still yet, just like the public defenders encountered the issues for. Funding, third-party funding may be necessary for a particular client, maybe an individual, maybe an entity that needs the funding to move forward. Sometimes we've worked for least developed countries. Money and funding can be an issue. It's still collaborative. It's still long-term, still intensive. And ultimately, and importantly, it's about quality over quantity. Another way to look at it is the old dichotomy about law being both a business and a calling. We a lot of times spend more time maybe talking about the business part of that than we do about the calling. But if you think about traditional lawyering and holistic lawyering, you might think about law as a business being more of a traditional idea and law as a calling being more in line with holistic lawyering. Again, it's a change of mindset. So let's move over and talk about regime interaction. This, once again, is the idea that there are different silos in public international law, and that in those silos that we see some developments in international human rights law, we see some in the international law of the sea, we see some international investment law, and that those things sometimes can say different things about the same legal issue. How does holistic lawyering look at that international context? It focuses on the whole client. It requires insight into the underlying needs of the client, not just a limited scope of engagement. It's compassion for human needs still yet, and especially here where we're talking about human rights related cases. It requires a perspective to span the public-private divide, especially what's implicit, inherent within investor-state dispute settlement. Some potentially relevant considerations. From the private sector standpoint, you might think of jurisdiction. You might think, for example, that a government won't listen to you if you don't have some proceeding that allows for jurisdiction, like investor-state arbitration. You might think about publicity, reputation. You might certainly think about commercial relationships in the event that there's a long-term commercial dispute that's arisen. Access to foreign markets, shareholder politics, and cost, ultimately, of course. All of these things could be driving concerns for the private sector that are outside the immediate legal discussion, the immediate proceedings. From the public sector, you might think about the freedom to regulate, again, publicity, reputation, diplomatic relations, inbound foreign investment, and domestic politics, including, especially for governments, a lot of times not being the one holding the bag. If there were a settlement to be made, you may not want to be the one challenged with some potential corruption in the event that the next regime to take over the country is not happy with the settlement that was made with a foreign investor. Ultimately, cost is also a concern, even in the public sector. So let's talk about how this looks in practice. One example that I would put forward is the work that we've done recently for the government of the Gambia. In 2021, we developed a model for the Gambia for a bilateral investment treaty. It's the Sustainable Investment Facilitation and Cooperation Agreement, the SIFCA. It's an innovative model bit. It received cabinet approval just this year. Very excited that that document is finally going to become public very soon. It's driven by client concerns, much more in a holistic way than in a traditional lawyering way. We look at good governance. The client was concerned, obviously, about human rights, about environmental protection, and also, of course, about inbound investment and investment promotion. It's about more equal sharing of risks and benefits and reducing the perceived power imbalances in ISDS that we've heard talked about by others here today. And finally, some of the innovative features that we included, many of these for the first time in treaty practice at all. An investor declaration of compliance with the UN guiding principles, and inadmissibility of claims against the state if that declaration turns out to be false. And coming back to Maria Lucia's point, that generally speaking, there's no right of action for individuals in the investor state context. Well, there is under the SIFCA. There are third-party claims available on the basis of internationally recognized human rights violations for individuals to bring up against the investor, and the investor has to agree to that when entering into investor state dispute settlement, much as the model that has been discussed on the X-strategy side. Compensation is based on that human rights record for the investor as well. And finally, jurisdiction over both human rights and environmental issues are included specifically by agreement with the investor before they ever enter into investor state dispute settlement. If they're going to enter at all, they must agree to it. This is a new conception of how we might use treaties to bring together, just as Rodolfo said, you need to bring together human rights and environmental considerations, also investment law, where they belong together, where they are related issues that span that public-private divide. You have to address them together. It's just that most investment treaties, treaty arbitral tribunals are not interested in doing that not because they're bad people, but because they're looking at the treaty itself, the bilateral investment treaty, other international investment agreement, and they're saying, where do you see this language? Many of those treaties were written a long time ago. The issues that we're seeing today are very different. And people have called for a re-examination of the system because they see that there's a crisis of legitimacy. That's what's been called in investor state dispute settlement. And a lot of it has to do with these very issues with respect to climate change and with respect to exactly what Rodger was speaking about earlier today, the fragmentation of public international law, where we're talking about some new developments for norms in the environmental side, some that have been around for longer over the investment law side. How do we bring them together? That's what we did, is brought a holistic lawyering mindset, and that's what we would recommend to folks to do. A quick example before we finish on the dispute side, largely, but not only, is the work that we've done in developing legal strategies. Some of the recent work we've done advising clients, and it's, once again, not all for disputes, involves international humanitarian law, human rights claims in Africa, Middle East, Europe, investment law, commercial arbitration, sovereign immunity, availability of mass claims and universal jurisdiction, all of these ideas that can be siloed in public international law or in private international law, and bringing them together in a particular matter is important. You have to recognize that there's an interplay between the public and private. You have to recognize the role of regime interaction in public international law, and you have to recognize there needs to be a strategic analysis and balancing, a cost-benefit analysis of coordinated courses of action that may come together to provide a particular client, whether that's a government or whether that's an investor or someone outside of the investor state dispute settlement system with a remedy. It's always unique to each client, the needs, the circumstances that a particular client has, and you can't come in with any preconceived notions. But what you can come in with each time is that mindset for international holistic lawyering. Thank you.
Thank you very much, Robert. I'll just add a postscript to what he said. We found that this holistic, broader, strategic approach to lawyering was born really out of necessity, because we were encountering a number of cases where we faced brick walls in terms of there not being an obvious cause of action. As I mentioned before, there was no treaty between the countries, or the contract had been terminated, or for whatever reason, you couldn't pursue a contractual claim. And so we were forced to start thinking what else can be done, other than to do what all lawyers had told these clients before: sorry, we can't help you. And that's what we said, well, we can't, that cannot be the case, right? It's unfair. We have to be able to do something. And I'll give you another example. So international investment law is particularly poorly suited when used as a tool to for a nation that has suffered damage as a result of the foreign aggression by another country. Right? That's not what international investment law was meant to do. Yet you will find that for a private entity, or even the state entity that has suffered loss and damage as a result of unlawful military action by another country, the options and remedies for compensation are very difficult to pursue. We're doing one at the moment where we put the actions the client could take into three buckets. One is actions you can take yourself. For example, possibly pursuing litigation before the courts of the aggressor country, unlikely to succeed, but theoretically possible. Maybe pursuing an investment treaty claim, but bearing in mind what I said, that that's not the purpose of an investment treaty claim. It's not for you to seek damages or compensation for when damage has been sustained by an aggression country. So one bucket was what they can do for themselves. Another bucket is what they might be able to procure others to do for them, or do in conjunction with others, mass claims and the like. And finally was what they might possibly be able to procure their state to do on their behalf, prosecution before the ICJ. So that's kind of a third example about how, out of necessity, we were forced to start looking at non-traditional means to try and get some sort of redress for the client. Whilst we do only have about 12 minutes to go, questions can continue thereafter, but I had one question to any of the panelists. we talk about human rights, which are primarily, if not exclusively, the responsibility of the state. It seems to me that treaties are increasingly being used by a state to delegate, hive off, or pass the buck, as it were, to an investor. But I think
ما نعرفش شو تخرج علينا ريت انت هنا نقص استنى نشوف عاد
wasn't me. And surely that can only go so far as the operation of the investment impacts, the rights in question, but not, there's no broader standalone obligation. So for example, if there's some indigenous people on the other corner of the country, not impacted by the power station that the investors is building, but their rights are being violated by some action or the other, that is not something that a state can pass on to its investors. And so surely a line has to be drawn between how much a state can seek to delegate. Stephanie, do you have any thoughts? Is it right that states can pass on this obligation to an investor?
They can. They can pass on rights, and they can pass on these kind of obligations. And I think when I listened to you and also to Rob's presentation, Africa and their investment treaty lawmaking seems to be at the forefront of putting these kind of obligations into the treaties. But we call them direct obligations because they are directly addressed to the investor, and not just saying the state promotes the human rights respect amongst their companies and so on and so forth. So we're shifting from a promotional language that was also mentioned by the other panelists to at least in Africa, to direct obligations. Now, against this direct obligations, be it in an investment treaty, be it in the business and human rights negotiations led by Ecuador, that is a different working group that is working on that, right? And even due diligence regulations coming from the European Union, headwinds. So I think none of these African treaties entered into force. They're model BITs. So I think it is theoretically possible, but I think the political maybe headwinds that are that these laws and treaties are receiving currently is something for which what would be the solution, right? How could we overcome this? But theoretically, yes, to answer your question, maybe in 1 second.
I think the problem with more balanced treaties is it will necessarily mean the cost of investment will go up because there's a shift of obligations to investors. You will need to carry out extra environmental studies. You will need to gently relocate indigenous people and compensate them and send them for counseling and, whatever it may be. So I can see it, and I don't think investors will be all that thrilled. And their host countries that are supposed to sign these new models, it's good in theory, it's aspirational, it's the right thing to do, but investors are pragmatic and hard-nosed, and if capital outflows are going one way, I think it's going to be tough.
Hodolf has raised a hand.
Yeah, Hodolf, I had a quick question for you. We've talked a lot about the impact of human rights and treaties. How might it impact a private international law contract? The underlying, for example, investment contract. Either as a cause of action or a defense, or in what way have you had any experience where you've had to deal with human rights law and a normal contract?
Yes. Yes, and a lot of my investment arbitrations are actually based in contracts. So I think personally there is not that much difference between human rights violations by states or by investors in the context of contract-based, investor-state arbitrations and treaty-based investor-state arbitrations, because at the end of the day, the behavior of the investor is the behavior of the investor, and the behavior of the state is the behavior of the state. in one of my current cases against an African state, the state in the context of that contract disputes before a commercial arbitration institution has initiated first a criminal investigation and then criminal proceedings against the client who is the investor. And frankly, that could have happened also in a treaty arbitration, right? So the fact that we have a contract in lieu of a treaty as basis for the arbitration doesn't differ that much. And I guess what I would like to add to this is that when you deal with treaty claims, by essence, you're dealing with public international law claims. When you deal with a contract, it's very interesting because those contracts usually are, governed by the domestic law of the host state. But whether it is expressed or not, those contracts are also governed, at least to an extent, by public international law, be it just by virtue of the fact that the contract is between a private entity and a sovereign, right? So at the end of the day, my take on it is there are some differences in the law applicable, maybe, but not that much. But perhaps if I can expand very quickly on that question, trying to tie back to the comment that I had on what was discussed right before, what I would like to say simply is a contract, you put two parties on an equal footing. Yeah. The concept of a contract between a state and a company is to say, in the concept of that contract, those two parties are on an equal footing. They have both rights and obligations, they go both ways. Investment treaties, they don't do that at all. In fact, they do the contrary. Investment treaties, they are one-sided by nature, right? And the little music that you hear in relation to, how ISDS is unfair and investment treaties, oh my God, they're so investor biased. Yes, they're investor biased because they exist in the first place. The concept is, at least the theory is, they exist in the first place to try to redress a little bit the natural imbalance there is between a private party, be it a person or a company, and the almighty state in which that person is operating. So at least that's the concept of the... I'm sorry?
I totally disagree. You need to ask yourself,
that's very good.
Who drafted these treaties to begin with, right? And when were they drafted? But you are entitled to your view.
Yes,
sorry
exactly.
to interject. I had a question for
yes.
Maria. You mentioned something called the Bangladesh Accord. I'm not familiar with that instrument myself. Could you tell us a bit more about it?
Sure, Raja. So thank you so much for the question. So this is a legal binding instrument agreement that was entered between garment brands and trade unions in Bangladesh. And the objective of this agreement was to ensure workers' health and safety in Bangladesh textile and garment industry. So the most remarkable thing about this agreement is that they agree to include an arbitration clause. As I mentioned during my presentation, although the trade unions were able to file 2 arbitration claims before the PCA, we were not able to see the case in the merits. So there is still a lot to learn from this experience and from arbitration as a suitable mechanism to solve human rights disputes. And also because some of the challenges that I might see and that I think that the lawyers in those cases had to assume are related to how to view this architecture of massive claims involving around 2,000 factories that were involved in that case. And also, I might say that they might have a procedural challenge to design a process where the workers will actually receive compensation. So although this binding agreement, it's a great advance, I mean, I'm really looking forward to see a case under this agreement on the merits to see how arbitrators actually solve these kind of disputes and solve these challenges that I'm identifying.
Thank you.
Rudolph didn't make his comment.
Sorry?
Rudolph, I think, had a comment before.
No, he's not allowed to speak anymore. I think we should give the opportunity to anybody online as well as in the room. If you, because once me and Hodolf get going, we'll be here for the next 2 hours. But yeah, please. Do we have anybody online? No. Okay. Robert, did you have? Sorry. Okay. Yes, please.
Sorry, I was late. I have a question. Coming back from ECO, where we spoke a lot about the human element and listening to holistic lawyering, which I really think is amazing. If I take my arbitrator's hat off and put my mediator's hat on, it sounds like a lot of that is the interest positions and how much. I know there's a little bit, especially for ISDS, to try to involve mediation. Conciliation was really something that never went very far. Are you seeing that in some of these new treaties, or trying to bring in, along with this holistic lawyering, other people than the arbitrators who can try to help those interests be catered to?
So the question, for those who thank you very much for the question.
Sorry, just come closer to the mic.
So the question here from the room is effectively, please add to it if I get it wrong, but effectively is, are we seeing in new treaty models or in practice, are we seeing a new focus on mediation and on other methods of ADR that might go along with the ideas of holistic lawyering? And I think the answer that I would provide is gosh, a lot of things. I wish everyone were here in the room so we could have the drinks afterward and discuss it at length. There's so much to say. But the idea, I think, in the first instance is, in my own personal experience, I've seen a renewed focus, a new interest in the required negotiation that comes before by treaty. Most of the time, there's going to be a required negotiation process, just if nothing else to check the box before you can move to arbitration. Many people think of it that way. I've seen a renewed focus and an interest by government parties in engaging with the investors who are about to bring claims so that they can maybe actually find a solution and not spend 4.5 years in an arbitration process. And so, yes, I think that there has been a renewed interest, at least from an anecdotal level. Now, coming back to the idea of holistic lawyering, one other thing I'd like to point out, though, is that it's not just about ADR. That's an important part of it, and it's absolutely true. What the question was referring to was the focus on interest in a kind of more of an integrative bargaining approach for folks who are familiar with that terminology, as opposed to a distributive bargaining approach. It's not just about that focus on interest versus positions. That's interesting and important, but it's also interesting across the board when you don't even have a treaty. We've had cases in which investors have encountered human rights violations, and those human rights violations have included violations of what, in some parts of the world would be a violation of the right to property. And those cases, a lot of times, walking in and speaking with a lawyer with a traditional lawyering mindset, the result of that evaluation will simply be, well, there's a contract, there's an arbitration agreement, there's no treaty. It doesn't look like there's much to do other than go forward with a contract dispute. But the fact is that those human rights claims a lot of times can move forward, and a holistic lawyering vantage point can recognize multiple claims, bring them together, and not to browbeat host states, but to help folks who have been abused with their human rights have been violated in one way or another, to try to get some sort of measure of justice in the context of investor-state dispute settlement or other international disputes. And so I think that's a more fulsome answer to the question that, yes, it's about positioning. Yes, it's about careful and creative approaches to resolving disputes in negotiation or otherwise. It's also about the legal strategy. Thank you.
Thank you very much. We are 3 minutes beyond our scheduled close, and I don't want to keep all of you any longer than we need to. I'd like to thank each of our speakers for their engaging comments, their insightful observations. There's a lot more that we could say and do in this space, so I hope we can continue working together. I hope the topics were of interest to those of you who've had the patience to sit through an hour and a half of us going back and forth. For those of you who are here in person, we can ease your pain by offering to join us for some cocktails and snacks. I'm sorry I cannot make the same offer to those of you online, but you have a standing offer to come visit us anytime and we'll buy you drinks. And with that, thank you very much, everybody. Jose, back to you.
Thank you very much, Raja. This was a fantastic panel, and we are thrilled to have had all the issues that have been discussed from holistic lawyering, integrating the human rights aspect in a practical manner through all the proposals, including those of integrating investors' obligations on human rights in treaties. The last thing I would like to say is that thank you, and thank you for all the attendees and the questions. We see that the attendance in WOW Singapore has been growing, and we also have, of course, individuals connected watching you and this session. Luckily, we're recording everything so that people will be able to see it whenever they want later, even at different times. So thank you very much. Wonderful panel. And we will be seeing you in the next panel. Have drinks and enjoy. Bye-bye.
Thank you very much. Bye-bye.
Thank you.